And it is my pleasure to welcome you all to this session today. Two great presentations on predicting legal outcomes. So the first one is Professor André Lage Freitas from Brazil. And also he's at the Universidade Federal de Alagoas and a co-founder of JustPredict. He will talk about outcome prediction in the Brazilian court system. And then we have Professor Elizabeth Tippett from University of Oregon School of Law, Professor Charlotte Alexander from Georgia State University, and then Carl Branting, the chief scientist of the MITRE Corporation, who will talk about or ask the question whether lawyering matters, and they will talk about predicting judicial decisions based on legal briefs. So two great presentations coming up, and should be an interesting discussion. And we have an hour, so each presentation gets about 30 minutes. That includes Q&A. So with that, yeah, before we start, anyone in the group, any news to share or any updates that they want to share with the group, please yeah, speak up now or use the chat function. All right. Well then, let's turn it over. Yeah, who's that?
Oh, it's Tao here.
Bravo. Okay, go ahead. Tao, we can't hear.
I have an announcement. I recently.
And now go ahead. Go ahead.
It's an article on African startups. Oh, can you hear me now? Okay, awesome. Yes. Yeah, I recently wrote an article on African startups and access to the internet, and what are the recent developments in the telecommunication space that can skyrocket African startups in the legal tech space. It was published by the Artificial Lawyer, but I'm going to share the link here. Yeah, thank you for that.
Yeah, put the link in there. That's great. That sounds very interesting. Please put the link to your article in the chat, and I'm sure folks will be interested to check it out. And if you're considering presenting about your work, yeah, please let us know too. So maybe we can set up a presentation. All right, yeah. Good.
Thanks.
Thank you, Thabo. All right, then over to our first speaker, André. Are you there?
Hi. Hello. I'm there.
Good. All right. Oh, we can see you. Perfect.
Okay.
So, all right, well, take it away. So please leave some time for discussion. You have until just about 2 o'clock Pacific time.
Okay. So I should include in Q&A at
least
30 minutes, okay?
Yeah.
Okay.
All right.
So
take
first,
it away.
Yeah, so can I start?
Yes, please.
Okay. Well, first of all, thank you very much, Professor Roland Vogel, for inviting me for this presentation. I'm very excited to hear from you, your thoughts on it. So I will now share my screen, okay? The whole screen, let me double check it, yes. So I suppose now you guys can stick, you can see now.
Yes.
The first slide, okay. So I am André Lage Freitas. I'm from Federal University of Alagoas in Brazil. And I'm also a co-founder of the JustPredict Artificial Intelligence Legal Tech and TESS, Artificial Intelligence Legal Tech for Real Estate Risk Analysis. Today, I'll talk about our agenda on case outcome predictions for Brazilian courts. And I'd like to start by quoting CodeX. I think that this sentence is very motivating. What happens when you combine legal code and computer code? So this is the place for scientific research, legal informatics, and entrepreneurship. And this is exactly what you do. So that's why I'm very happy to show you here what I've been doing to get your thoughts on it. And when we first heard about it and this field, I fell in love in this subject actually, and then I pivoted my career to that. And I was looking for startups that could predict legal decisions, and we have some of them work on that more than these. But then I was surprised that I couldn't find any product, either research paper, scientific research paper on these. So then I invited my peers to pioneer a roadmap on case outcome prediction for Brazilian courts, which is a very ambitious challenge, actually. And I'm talking about here both scientific research and innovation. So that's why I divided this talk in two parts. First part of it, I will talk about our paper and other research questions we are interested in. And then I'll talk about a little bit about Just Predict, and I will do a live demo with our MVP. So I work in this subject with Assistant Professor Hector Allende Cid from Universidade Pontífica del Valparaíso in Chile, and Assistant Professor Orivaldo Santana from Federal University of Rio Grande do Norte in Brazil. We are actually the data science of this interdisciplinary team. And along with Livia, she's a prosecutor and attorney. She's actually a special assistant attorney from the State Attorney General here in Alagoas. And we worked together for some years. And this paper actually was first published as a technical report in an archive in 2019, and it's under review in a Web of Science Index journal currently. So in this paper, we propose a methodology for predicting Brazilian court decisions, which starts with by scraping data, legal decisions, scraping websites from the courts, and after getting these data, cleaning it, we pre-process the data set. We use natural language processing modeling to represent these, the text. And then we separate from the legal decisions, we separate them. Basically, in this study, we are interested in the description of the case, the decision, the text that refers to the decision itself, and the text that refers to the unanimity. This means in a minute is the text where it's written where either the three judges, they voted together because we are analyzing upper court, the appellate court decisions. And in Brazil, we decided it is actually three judges that decide together the case. So we extracted the data from the Just Court of Alagoas. It's the appellate court in the state of Alagoas. In Brazil, we have states like in the United States. And we scrapped 4,000 decisions. And then we, after we separate the decisions and the unanimity, we label it if it was denied or converted, and if the judge were they were unanimous on the decision. With this labeled data set, we use some classifiers and we train them to analyze to see if the prediction text, the task would be successful. So our results showed an F1 score for the decision prediction task between 70 and 79%. And XGBoost and SVM models, these classifiers were the best ones. For predicting if the judges were unanimous or not, we got an F1 score of 81 to 84%, and random forest and decision tree were best models for these tests. So as a conclusion, we can affirm that we have proposed a simple and effective approach to predicting Brazilian court decisions. It's very interesting, and actually we expected that because we use the same approach as previous papers in the literature, But these papers, they usually use data sets from the European Union Court, Human Rights Court, or United States, for example, or other countries like China. So we could verify that it's also a simple and effective approach for Brazilian law also. And we realized actually this was our very first version of our Just Predict MVP. And we used it to validate with some customers by using Stevens Blank customer discovery method, and realized that the percentage predictions, they weren't enough for example, selling a product. And we also realized that very few attorneys were interested in unit prediction, for example. So what did we do actually? We redesigned our algorithm because we did need relevant to provide, in addition to the percentage prediction, to also tell how we rated these predictions. So it means basically to tell, here goes the list of lawsuits that were more important and relevant to achieve this prediction. So we had to redesign from the scratch another algorithm by using other models, and natural language processing models and machine learning algorithms. So we deployed a new version of Just Predict Oracle. This is the name of our MVP. And it uses today much more relevant and important court. It is the Justice Court of São Paulo, probably the largest in the world. It's very huge, this court. And we always have to keep in mind that user experience, it's really a challenge, actually, the status quo. Because actually it's a common sense. And when we're talking about lawyers, some of them, they're very afraid of trying another technology. So user experience must be really, really, really simple. So regarding other research questions we are working on, and we are interested in understanding, most of them are my students. Bruno, for example, he is using classifiers to understand how they would perform by classifying the decision text, the text that refer to the decision itself. Okay. Thalissa, she's using clustering to extract legal insights from legal documents. Basically, she's actually understanding how unsupervised learning can be useful to get insights and visually speaking and other kind of understandings. Naelson, he worked in a very interesting subject. He applied named entity recognition to identify potential frauds in public contracts. We asked, we had more than 3,000 public contracts from the Alagoas state, and he applied named entity recognitions. So he could plot some histograms and show that maybe this place could have some potential frauds. And Julia, she is working on how to identify law violations against women in social networks. Basically, she is getting Twitter posts and understand if they have any violations of Maria da Penha law. It's a Brazilian law. It's a very beautiful interdisciplinary field she's working on. Actually, she proposed me this subject to work, and I just proposed to let's compare to Maria da Penha law, but she was also interested in this subject. It's really beautiful. And these are prosecutors, Livia, as I introduced before, and Evandro Lemos. And these I'm very excited about because actually they proposed me this to work with blockchain to speed up and to build a safer public contracts by using smart contracts. So I'm very happy because there are some lawyers or prosecutors like proposing some very interesting research problems to work with. Well, now I will talk about Just Predict. I will focus now on the legal tech part of my talk. First of all, we have quite some legal tech startups in Brazil. Some of them, they are not actually startups anymore, or they're like a big enterprise. But we have only few of them working with analytics and geometrics. Actually, as far as I know, and we have investigating products, there is no product that in the world that can predict decisions by use as input, the initial application, or the case description as we do. We're talking about here a huge market. We have in Brazil more than 1,250,000 attorneys, more than 3 million lawyers. We have more law schools than the world together. We have more than 1,200 law schools in Brazil. And we have a huge backlog of court cases, more than 8 million. And it's $1 billion market. The legal market in Brazil, more than $9 billion, which is today around 50 billion Brazilian reais. So I will now present to you a live demo of Oracle, as I told you before. I will open my browser. Let me do it full screen. I hope you can see it. Let me just move Zoom from here. Okay, it's better. So how it works. The first screen actually is when you put your initial application or the case description. You can either send a PDF file or you can send a text. I will paste here initial application sample, record, and when I click predict result, okay, it's a live demo. We got an error. Let's try again. Okay, it worked it out. So it's processing in background, and when it's finished, it will appear here like these ones. Meanwhile, let me check this one here. So this one, what is the output? We show the percentage, the probability of being converted, of the judge saying yes, and the probability of saying no if the court denied the appeal. We also, this is actually what is more important actually. This is the very, very good value proposition we've been validating with customer discovery model. These are the lawsuits more important that influenced this decision. And we have here and we can explore more actually documents associated to this lawsuit. For example, the initial application, we can actually click on it and we can copy and paste and take a look and so forth. And down we're gonna have the input that the user did. But let's come back, and here it goes, the one that I just asked to process right now. So here is the results actually, same thing, you can click and access the data. Okay, so lessons we've learned here is, first of all, let me present it back, okay, it's very simple, very simple, very simple, and as is it should be. Why? Because the customer must be in the center of everything. We take it very seriously, the lean startup method in Just Predict. We are very happy to have a very, it's not as quick as we'd like to, but it's a kind of quick build, measure, learn feedback loop, okay? And we are constantly apply some improvements on our tools. So here is the Just Predict interdisciplinary team. We have people from the legal researchers, Livia, she's working as a consultant here for us, and José Filho, he is a legal data scientist an attorney, and his PhD is in geometrics. He's a lawyer that he codes. He knows about statistics, and he codes in R. He understands a lot about SQL. It's a really interesting profile. So we have legal researchers, and we have data scientists with AI and machine learning profile as well. In addition to them, we are very proud of our developers. They're really good work we've been doing there. It's really nice team. So what are our next steps? Well, we have done scientific research, okay? Scientific research, from scientific research to innovation. I'm really happy that we can work on both worlds. It's not easy at all to work on both sides at the same time, but we are kind of managing to handle it. And as I said, we have the first legal prediction research and production for Brazilian law. So we are here right now with Just Predict. We are opening, testing, validating with early adopters. We will perform more A/B tests on it. And we are headed to, as far as we have our product market fit, we'll work on our network effect and eventually look for same funding and test other value propositions. We have a lot of hypotheses in our Canvas business model, and we'd like to try and to validate with customers. So this is the end of my talk. I'd like to thank you for listening to me, and I'd like to thank again Professor Rodney Fogg. And I'm all ears. I'd like to listen from you. Please give me feedback, advice. Please do critique, send your feedback on this talk. I'll be really happy to listen for you.
Thank you, Andre. Great. So folks have already posted a couple of questions in the chat. So Carl, for instance, he's asking how many decision categories were you predicting?
You mean the decision if it was reverted, denied? These are the categories he's talking about?
I don't know. Carl, can you specify?
Let me open here the slide.
I just meant in the original experiment for which the F1 scores are being reported. So that was just a binary classification, or were there other categories?
Both. I didn't put it here because I didn't have too much time, but I can open the paper and show the categories. Actually, we have 3 scenarios, and let me open it here. Okay, here. Okay, for decision prediction, we have 3 scenarios. The first 2, they suppose that we have a 3-label classification problem. And the third one is a binary one. Did I answer your question?
Yes, that's fine. Thank you.
Okay.
Jana is asking if court cases in Brazil are all written in a semi-structured way.
So,
are they structured, the decision, the text?
Sorry.
Is it just text? Is it just text, or are they structured?
The structure. Maybe I can open one accordion here so you guys can take a look.
From you can answer from your slide. Look at your slide. You say,
Sure.
Can you go back to your slide?
Yeah.
When you say this last part where you say the decision, you have description, decision,
okay,
unanimity. So it's actually semi-structured, even in terms of text. It's, you know where the things you are talking about, they're already in a certain structure, I mean, right? Otherwise, you cannot do this text segmentation. That's
Okay.
what I meant.
Thank you for the question. Actually, I would say it's completely unstructured.
Great.
Yeah.
So how does this work then? In your text segmentation, you put one particular type.
Well, actually, there are two ways of doing that. I'm going to tell you the hard way and the worst way. That's what we've done, and the way we are doing right now. This first paper, we've been working with the summary of the decision itself. So the text is not as long as a full decision like that. This is a full decision, okay? A lot of pages. And we are working with the summary. It's smaller. And we developed an algorithm that looks for where the judge, how can I say, the text, and we separated it by using regular expressions.
Okay. Yeah, so that means you look for the summary, and the summary is in a certain location in a document. So it is semi-structured.
Because usually, since we've been working with, for this paper, Kurt of Alagoas, most of them, it's description, decision, unanimity, like this. So it makes it easy.
Exactly. That's what was my question. That was my question.
Other Brazilian Kurds, they're not that. That's why we.
Exactly. So it will be much more difficult. It will be much more difficult. Another follow-up question, and Carl has the same issue we talked long time ago. PDFs to text, it's not so straightforward usually, especially if the PDF is not real PDF but image. So you need some OCR techniques and so on. Yeah. What is your experience with that? That's it.
Well, honestly speaking, I cannot talk very much about that because I don't understand too much about this. I know one or two libraries that can do the OCR. I think TerraSart is the standard. So we've been using this. So it's something like.
Sorry, Andre, but I meant do most of your documents, or probably all of your documents, are actually real PDF, like the court cases. Okay, that's it. So you don't need OCR if that's the case. That's what because what we face, and Carl also faces the same problem, is that if the PDF is not real PDF, like you cannot transform it into and extract the text, then that would be
Yes, actually the PDF, it's a nice PDF. It was generated from Word, for example. So it's straightforwardly to convert it, but it's not that easy to extract information from it. The good news is our current algorithm, the decision, we get it from the website. Hopefully the courts, they put the decision, it's called dispositive. So we get it's easier to get the dispositive and straightforward. We don't need to look from the PDFs.
So we have a couple of other questions and not very much time left, Charlotte's asking, is the case description the initial application that is the input written by the judge or by the parties? She's unclear as to whether
good
this
question.
is...
Very, very good question. By the judge, okay? This was actually, we've been discussing on that because, and I was worried about like if our natural language processing model, they would be biased because maybe the judge wouldn't express precisely as lawyers precisely express themselves. But we suppose that they do.
Okay, interesting. Jana also asked, who are your customers?
Sorry, asking what?
Who are your customers for your company?
Actually, the product we are not selling it. When I say first sell it, it's Steve Blank sentence. Like sell means find your product. When you find it, you accelerate the enterprise. So in a nutshell, our customers are lawyers. Okay, will be lawyers when you start to selling it.
Mm-hmm. Okay, good. So Raja is saying, did you check if the case description doesn't contain, going a little bit back to the same question before, that the case description doesn't contain signals informing the outcome independently of the facts. For example, some key phrases could be used by the judge only when the outcome is negative. In this case, the model would be learning spurious correlation.
Let me repeat it to know if I understand it well. Some initial applications, they ask like 5 things, and it's hard to know if it was yes from one thing or another one. Is it the question?
I'm not sure. I think the question is whether the judge, in a way, he writes the case description. It could already foreshadow, I think, what the outcome should be. Raja, do you wanna elaborate?
Yes, it was what you were saying. Sometimes in some decisions, I know this in, for example, in French decisions, the structure of the case will depend on the outcome. So if the machine learning algorithm, we only give it the structure as it is, then it will be easy for it to pick up this heuristic, just learning to differentiate the outcome by learning to differentiate the structure of the decision. And sometimes it is used also by the students to just quickly see what is the outcome of the case without really reading it. So I was asking if that's something that was checked manually, and to see whether the algorithm learned to predict by understanding the facts or by picking up other signals like the keywords or the structure of the case.
Okay. Actually, we are using as it is. And what you're asking, actually, it's an open research question. Okay, and it's, in my opinion, maybe you guys can disagree. It's very hard and interesting problem to solve this. Okay, and as we are modeling using embeddings, we tried actually to separate the facts, the fundaments, and the vote. I don't know in French. Okay, I forgot how it's in French. So we tried to separate to do this segmentation in the decision, but it was very hard. So just answer your question straightforwardly. We are using as it is.
So Andre, we are unfortunately a little bit over our time already, and there's a lot of praise for your presentation and some additional questions. So might I ask those folks who have additional questions to reach out directly to Andre. Andre, please put your email address into the text, into the chat. Okay. And yeah, please everyone join me in a quick sort of round of virtual applause for Andre. Very cool work. Really appreciate you sharing this with us, and it's interesting to see what's going on in legal prediction in Brazil. Please keep us posted. And yeah, so thank you again for joining us. Let me turn it over now to our next speakers. Elizabeth, Charlotte, and Carl. Are you there?
Hi.
Hey.
Hi.
How are you?
Great.
Okay. And Andre, could you please unshare your screen? So
let me just take a look. How can I do it?
I think yeah, you have to, on the bottom of the screen there's like a button for unsharing.
Okay, so
in Zoom.
Please tell me.
Yeah, go on Zoom. You click the Zoom button.
Zoom the button.
Yeah. Go to the center, down to the Zoom. Yeah, left.
Left. Ah, okay.
The little camera is the Zoom icon. Do you see the camera?
Sorry, guys.
We can see it.
Okay, let me do something here. Stop video? No. Okay.
Yes.
Thank you.
So, thank you, Andre. Okay. All right. So over to Liz, Charlotte, and Carl. It's great to have you, and we're excited to learn from you whether lawyering actually matters. So so that will be interesting to hear your thoughts on that. So thank you again, and over to you.
Okay, great. So I'm going to hand it off to Liz and Carl and then back to me. So thanks a lot, everyone. We were really excited to be coming after Andre's work because I think it's as if we planned this. So as you'll see, what we're interested in doing is predicting decisions from the parties' briefs. So we are attempting to do, I think, what Andre just described as being hard and interesting, and you all can assess whether you think we succeeded. So Liz, could you advance? So generally what we're interested in here is trying to assess what the extent to which the writing that lawyers do in their briefs is predictive of judges' decisions. And there are different ways we could think through how the text in legal briefs might influence a judge's decision. There, as some here are on the screen, the lawyers might be signaling different aspects about the strength of their case. They might be actually highlighting parts of their case that are quite strong and distinguishing bad parts. They might be actually making persuasive arguments. They might be citing relevant case law that is itself persuasive to the judge. So Liz, can you advance? We actually try to structure our thinking around legal writing by looking at what law students learn about legal writing. And so we made our way through a bunch of legal writing texts to try to understand what the norms are that define good legal writing. And so here we saw there's some summaries on the screen. I won't read them all, but there were some general rules of thumb that seem to be consistent across these texts. So use short sentences, be careful with respect to which kinds of intensifiers or adverbs you use. So you may overstate your case if you're saying things like clearly, obviously, evidently all the time. Avoid string cites, so meaning lists of authority just separated by semicolons. And then be careful with respect to your citations that you choose. You're going to want to choose old and new cases to cite. So next slide. So we were thinking about those particular aspects that we could actually record as features of these briefs. And Liz will talk about the particular corpus that we assembled. But obviously the aspects of the text of the briefs that we're going to study are not the only factors that may influence the outcome or influence the judge's decision. So we are not making a claim that we are able to capture everything that influences outcome. So obviously there are other aspects of lawyering there's that influence outcome. The judge, him or herself, may have a particular ideology or approach that informs outcome. And then of course, there are the merits of the case. So to some extent, there's some irreducible, perhaps irreducible sense of whether a case is a good one or a bad one, regardless of whether how skilled of a writer a lawyer is. So acknowledging all of that, nevertheless, we were still quite interested to see what we could do to squeeze something out of these briefs and see what we squeeze out and whether that's predictive of outcome. So next slide. All right, so Liz will talk about the corpus and our methods and findings.
So we were looking at employment law cases and employment discrimination cases that were filed in federal court. And so we used a random sample of cases from a 10-year period, which we got via Bloomberg and Pacer. So we actually had law students download the cases in code and the decisions in code, whether it was the plaintiff side or defense side brief and who was the moving party. And they also read the case and coded the outcome. And so of these 854 cases that the law students downloaded, we were able to use about 444 of them. We couldn't use the ones where it didn't seem to be a complete set of briefs from all the parties. We also didn't use the ones where there was a partial outcome, and that ended up skewing our data set a little bit because the partial outcomes tended to be favorable to the plaintiff. So you can imagine if a judge grants a motion for summary judgment in part and denies it in part, that's favorable to the plaintiff because part of the case survives for trial. Those did not end up in the in what we used, we only used the all or nothing decisions. And then there were also some decisions we had to discard because multiple motions were decided in a single opinion, and that was too complicated to handle, although there were a few cross motions with separate rulings that we were able to include in the corpus. So you can see in the slide, we talk about the skewed nature of the data set. It was mostly motions for summary judgment filed by the employer, and the employer won in 76% of those cases because we were only using the all or nothing decisions. And for reporting on the results, we used the Matthews correlation coefficient, which if you're not familiar with that particular coefficient, like a 0 on that scale would mean like as good as random as a predictor, and a score of 1 would be a perfect prediction of every result. So here are the different features that we use in our models. So one of the things we did was we reviewed a subset of the briefs to try and identify relevant stylistic features that somewhat aligned with what you see in the legal writing literature. So some of those were about using intensifiers, and the legal writing literature makes a distinction between like ones where you're overstating the case, like saying obviously, versus like the more posh version of that, like saying the word precisely. And they advocate saying like the precisely, but not obviously. So we made a distinction between those two types of intensifiers that we found in a subset of the briefs we reviewed. We also looked at some other features, like whether there was hedging language, which we thought might be related to the facts, or whether they were using intensely emotional words, which we thought might be related to the merits, or repetition. We also looked at some sort of summary features of the briefs, like the length of the brief, the number of documents that were filed. And then a lot of the analysis, which we'll talk about more, is the citations, which ended up being really important. So some of it was about the summary statistics associated with the citations, like the number of citations, but then we also used each citation as a unique variable. We also included a number of control variables, which ended up being less impactful than we expected, but they're in our model. So here's what didn't really produce very meaningful results. Just based on the raw text, that was not so helpful, or the raw text that was just the parentheticals, which if you're familiar with brief writing, the parentheticals only contain like a small piece of the legal argumentation. So I think that's why that one ended up being very predictive. Textual similarity, not too helpful. Citation overlap, not too helpful. The other piece was merely knowing whether a particular brief was filed by like the moving party filing for summary judgment versus the opposing party. That produced an MCC of 0.48. So that was sort of like the baseline we were competing with in the various models that we used. So our stylistic features actually ended up being kind of interesting, or a combination of the stylistic features and some of the brief characteristics. So here's one of the models that worked pretty well. So how many pleadings did they file? Did they just file an opening brief, or did they file an opening brief plus a reply? How many citations? More than 26 or less than 26? The use of the positive intensifiers, those were like the posh intensifiers, precisely. And then how long were the string cites? The legal writing experts advise not using string cites that are too long because they say it's overwhelming. So this ended up being pretty useful. But if we were just looking for one piece of information from our briefs that ended up being the most useful, it actually ended up being the citations. And in particular, the unique citations. So there were 15,000 unique citations within our corpus. And if we stripped it down to the 100 highest information gain citations, those actually were pretty predictive, surprisingly so. And it actually ended up being even more interesting when we looked at the particular cases that were that provided the most information gain. So here's some examples of the cases that produced the most information gain. This was very surprising to us. We thought that it would be Supreme Court decisions. You know, in law school, we teach students Supreme Court decisions. Most of the textbooks contain Supreme Court decisions. We don't spend a lot of time on these appellate court decisions. You'll also note that the most influential decisions here are from the more conservative districts. And that might be partly because of the skew of our data. I mean, remember that our data excludes some of the positive rulings for the plaintiff. And so in that context, the impactful cases that are employer friendly, like that makes sense. So when we actually went and read these cases, each one of them stands for like, basically like a little get out of jail free card for the employer. So of these top cases, only one of them was employee friendly. It was the one at the very bottom, which was a reverse discrimination case. But all the other ones were employer friendly. So, so for example, the top case, Elrod, that was a case where like this man filed an age discrimination case, but he had also engaged in a whole bunch of sexual harassment. So that case like stood for the proposition that you can throw out someone age discrimination case if they're a horrible sexual harasser. Or the next one, the Hawkins case, that stands for the proposition that if you have a personality conflict with your subordinate, then that doesn't qualify as discrimination. And so you can imagine how that would be a really powerful case to cite. And so each one of these is like a little constellation of law and facts that meaningfully might contribute to the outcome of the case if in fact your case actually resembles that case. That's what we think is happening with these top cases. I'm going to turn it over to Carl now, talk about the graph analysis.
Thank you, Liz. So another aspect of the citations became apparent when we modeled the citations when we applied a couple of different graph models. So this graph model, in this one, we modeled our data as a bipartite graph. That is a graph in which there are two kinds of nodes, one representing briefs, one representing authorities, and all edges go from a node of one type to a node of the other. In this case, it consists of having a citation. And representing our corpus in this fashion made it, it facilitated calculating certain kinds of metrics that turned out to be pretty useful. For example, if you start at a brief and all the brief's one-hop neighbors are going to be the things that are cited by that brief, the two-hop neighbors are all the cases that cite the same things as a brief that we're looking at. So one kind of particularly useful sort of way of estimating the quality of a brief is to for a brief of a particular kind, like a movance brief, if I look at all the two-hop neighbors that are movance briefs, that in other words, they're trying to achieve the same thing, and to use those neighbors to calculate the probability, the observed probability of success of citing the cases that are cited by the brief itself. So in other words, for each thing that's cited, how good on average is that precedent for other briefs that are in a similar way trying to achieve the same goal. And if you average across those, that turns out to be a metric that is actually pretty predictive of the node itself. So intuitively, you could think of this as what's the success rate of other briefs that have cited the cases cited in this one. So if you go to the next slide, please. So if we look at this top row, let's just pay attention to the very first feature. That's the very most informative one. The others are basically sort of variant. So the average citation win score of the precedents that are cited in a given case. So it turns out that that's actually pretty predictive when we consider all the briefs as a whole. If we segregate the briefs by whether they're movements or respondents briefs, then the accuracy is not as high. And perhaps that's kind of surprising, but it turns out that movements and respondents tend to cite different cases, unsurprisingly, and therefore that information about the nature of whether it's a movement or respondent is sort of implicit in the citation behavior, and therefore distinguishes between these two cases that have a different baseline. when we combine them. But if we look at the individual categories separately, we see there's still a good bit of information that's expressed just in this average citation win score. That is, how well have other cases, other briefs that cited these cases, how well have they done? So rather predictive. So you want to be citing cases the same way that successful prior briefs have cited them. Okay, so that's one kind of graph analysis. The second one is another way of sort of looking at this corpus in graph terms. Suppose we make a graph that consists just of briefs, and two briefs are connected just in case they have any citation in common. Okay, and so in this graph, if we look at the number of neighbors that a node has, that's equivalent to how many other briefs have cited the same case, at least one case in common with this. So one edge case is if that's 0, that is, if a brief hasn't cited a single other case that any other brief has cited, then that's a kiss of death. That's an indication that this is not an effective brief. And as a matter of fact, they all lose. And as we sort of graph the number of neighbors, so on the horizontal axis, we have the number of neighbors. The vertical axis is the probability of success. So oddly enough, there's a correlation between the vertex degree in this graph, which is how many citations, how many authorities have been cited by some other case, and the probability of success. So once again, this is an indication that that sort of normalcy is a good thing. That if you're citing a lot of the same cases that somebody else does, that's an indication of success. Whether it's cause or effect, we don't know, but it's certainly an indication that this is more likely to be successful. And that's it.
So that's back to me. All right, great. So apologies to those of you who are not steeped in US civil litigation. I put a little primer on summary judgment in the chat, realizing that we neglected to do that in the beginning. But essentially, so boiling this down, right? So we walked through the different aspects of the legal text and talked about what we found, and then we really found these interesting results with respect to citation. And so why might citations matter here? One of the underlying things that's difficult for us conceptually is to figure out to what extent the merits are operating here and to what extent the citations are actually a proxy for the merits. If anybody has a good idea for actually objectively measuring the strength of the merits of a case, please tell us. But we think one thing that could be happening here is the citation patterns that we're observing are actually a proxy for the merits. So the better cases tend to win, and the lawyers in the better cases tend to cite the same set of precedent. Also, by the way, the lawyers, better lawyers who are better at winning may also select better, stronger cases. So there may be a selection effect here as well. But I think sort of, if you'll allow us to kind of set aside the merits complication, we do think that citations do signal that more citations and better citations suggest that lawyers add value through research. And how do you get access to a lot of good legal research? Well, you have a lot of resources. And so I think this is actually maybe perhaps an old story suggesting that well-resourced clients hire well-resourced lawyers who have access to expensive research services like Westlaw and Lexis and junior associates to do that work. So poor use of citations may signal bad lawyering. It may also signal poor lawyering, poor in the sense of under-resourced. So next slide. Okay, and so I saw Jana put in the chat, well, hey, lawyers don't follow the advice of their leading legal writing instructors. So one question here, apart from citation, is that true? Do lawyers actually, well, this is not whether lawyers follow the advice, it's whether the advice actually holds up. So not exactly addressing Jana's question. But the advice about the weight of authority in old and new, so that's, you know, generally seemingly kind of true. So more citations help, and there seems to be from the neighborhoods that Carl was describing in the graph analysis, there are neighborhoods of good cases that signal the weight of authority. So if you put yourself in that neighborhood, you're better off. The string cite advice also seems to be true. Those lengthy string cites don't seem to boost your chances of winning necessarily. So it's not a question of just throwing in string cites. It's a question of which cases you're citing. Positive, as Liz already covered, the intensifier results, and then the sentence length itself wasn't too helpful. Okay, let's go to the next slide. And so thinking about takeaways here, where we started thinking about, well, what does it mean to have a lawyer and what functions do lawyers perform? So here, there's a ton of research out there showing that having a lawyer, period, is beneficial versus being pro se. Here, our pro se covariate actually was not statistically significant, so we didn't actually find that, but which is curious, and we're still puzzling about that. But it does seem that more intense lawyering, meaning filing more briefs to convince the judge of your side of the story, does make a difference. We already went through the promising avenues that we're exploring here with respect to legal writing and stylistic characteristics. Just other things we tried to classify the different argument types that were being made in the briefs. That didn't really work. And then lastly, we talked about this question of the merits and citations and what those really mean. So I think that is it. Liz, do we have another slide? Okay, yes, that is it. So thanks so much. Really glad to be able to share this work and really interested to hear everyone's thoughts.
Great. Well, thank you, Charlotte. So folks already have a couple of questions. So Jan is asking, the issue with citations affecting the decision and that most cases were employer friendly. Is it possible it is a correlation or a graph analysis bias?
Well, I would say that's one of the reasons that we sort of use MCC as a measurement, is because it tends to qualify the performance relative to the baseline of the original distribution.
Okay. Mark is asking if lawyers utilized en masse a tool that uses the average win of citations as a predictive strategy, would this risk creating a concentration of similar citations and thus a groupthink effect in the justice system?
I guess I have a different feeling about that, which is what Charlotte mentioned with respect to access to lawyering, right? Some lawyers have a lot more resources than others. And I don't think it would be terrible for resource-constrained plaintiffs' lawyers to have access to something that makes it really easy to find the relevant case law so they know what to include and what not to include, rather than including like few citations because they simply don't have time or they don't have access to a huge brief bank, which many large law firms do. So, I mean, I think the question of like, is this overboard is more true for big defense side lawyers that already frankly have access to a ton of case law through their internal brief banks.
I would add, so one additional thought kind of in line with what Mark suggested is one worry I have in the field of sort of litigation analytics on the plaintiff side is that that you may end up with this sort of path dependency or groupthink where if we see, for example, that race discrimination claims by African-American women don't succeed very often in court, then what that might produce is that plaintiffs' lawyers may be less likely to take those cases on. And so similar to what Mark's suggesting, I do think there's something to worry about here, where if we're allowing past, this is not new to anybody on this call, but we don't want to get stuck in the biases that already infect our court systems, and be aware of that potential problem that you're mentioning, Mark, and actually an unintended consequence with respect to access to justice, perhaps.
Okay, so Bruce is asking, can Hornbook citations be organized so pro se and small law offices can compete better? I think Liz sort of addressed that already. And then Brian saying, makes sense that case citations matter in a common law system that cares about precedent. It would be interesting to see whether the results hold up in a civil law system that emphasizes precedents less. Perhaps statute citations might matter. Any thoughts on the civil law, common law?
I also expect the results would vary based on types of law, even within the US, because we're dealing with employment law here where there's a very vast amount of varied case law you might cite because the fact patterns vary a lot. You can imagine a different context with more constrained fact patterns and a more constrained body of law where this wouldn't work very well.
Yeah. So I'm there's a couple of more questions, but we are sort of over time already. So if you could, I actually like to have, maybe I take the privilege of asking the last question then, which is, so what's the next step for this research? Where do you see this? Do you want to make the existing research tools better? Do you want to sort of level the playing field and create a new research tool that the self-represented litigants can use or poorer lawyers can use? What's the overall goal? We're just interested in finding what's actually what are the factors that actually influence in the briefs that influence the outcomes.
Liz?
I'll start. Yeah, go ahead, Carl.
No. I was just going to say.
Okay, I don't think we quite know. In fact, we were on here for the sound check, and in the few minutes before everyone else came on, we were just the three of us having that very conversation. So, I know there are players out there in the marketplace already that are doing things around automated brief writing and things like that. And so there are, some companies that are attempting to fill some of this space, but I don't think really with a sort of legal services, low income client, poor lawyer type orientation that we have been talking about. So I don't know. I think goal one is, to push out some papers. And as we do that, we're thinking about where else we might go.
So I guess I would add to that. It seems like there is from the standpoint of the analytics having to do with citations, that there's a kind of obvious application having to do with improved citation identification. If I have a model that tells me how well a particular set of citations are likely to do in a particular case, then that's going to guide me in my citation behavior potentially. In order to sort of scale that up, I think a lot of data is required. So from my perspective, what we have here is a pretty focused domain in which we're able to sort of control for an awful lot of variables in terms of subject matter. And so we can focus on this interesting phenomenon that sort of successful and unsuccessful briefs tend to have a lot of commonalities, especially successful ones. And so you could imagine having a kind of model-driven selection process, but the model itself would have to be specific to these individual, pretty specific topical domains. This is a narrow one. There's a zillion others. If I have unlimited data and computational resources, then I think you could think about creating a kind of citation graph model for any topic and then using that to guide yourself. But anyway, pretty data intensive process, I think.
And I just want to add one other perspective to fill in on what Carl just said. So to give you a further sense of behind the scenes here, so we had to have law students identify so we had a set of summary judgment decisions that we knew existed in employment law cases. And then we had to find and download all those briefs. And of course that costs money. If PACER were free in the United States, so call your representative and tell them to support the free PACER bill, then we could get access to briefs filed in court easily and in bulk. And then we had to have law students hand code what the outcome of the cases were, back to Andre's presentation, for example, in order to identify what the outcome was. So this was quite labor intensive. And if we had access to the documents and to the courts more easily and in bulk, I think that would make these types of projects much more feasible.
Okay, well, it's good. That's a good point to kind of end on a sort of call to action. You know, call your representative and push the PACER reform. So, well, this has been great. This is so interesting, and so if you could perhaps put your email address in the chat, so if folks have additional questions and they know how to reach you, that would be fantastic. And thank you. Yeah. Thank you all so much again for joining us today and presenting. This is a very cool, cutting-edge work, and so I hope you were also it was also some helpful feedback that you received, and thank you also to Andre for sharing a little bit about the Brazilian court prediction landscape. And so we will be meeting again most likely next week. Stay tuned. We'll be sending out an announcement early next week. And quick round of applause for all our speakers. Thank you again for sharing your important work. And please keep us posted. And see you next time. All right, good to see you all. Thank you.